Let me tell you about failure to disclose issues that arise from real estate transactions. A failure to disclose situation within a real estate transaction can be very costly and may result in the inability to even move into your property after a purchase. It could result in a forced cancellation of a previously closed transaction, or you may even have to pay back the proceeds from the sale of your property. Whether you're the buyer, the seller, the agent, or escrow company, everyone involved in a failure to disclose real estate issue needs to take this seriously. Either way, knowing how to properly navigate a failure to disclose issue within a transaction is very important. There are three main things to really look for. One are the elements and what California law requires. The second are what potential causes of action can you bring based on the facts and circumstances of your case. And finally, what type of damages would you be able to recover on your matter? California law requires that a seller in a real estate transaction formally disclose anything that adversely affects the value or desirability of your property. The seller and the brokers involved in the transaction are also contractually and statutorily obligated to disclose all the known material defects to the buyer. Now, just because a seller has obligations to disclose issues with the property, this does not mean that the buyer doesn't need to exercise reasonable care and judgment when purchasing a property. The buyer has the obligation to conduct a fair and reasonable inspection of the property they intend to purchase. So even if a defect was not disclosed to them, the buyer may not be able to hold the seller liable if that defect was something they should have known about or would have known about had they done a reasonably thorough inspection. That said, there may be cases where a seller intentionally conceals a defect that would otherwise be observable, or partially discloses a defect by downplaying its severity. In those cases, the seller can still be held liable. Now, there are several types of claims you can pursue in a failure to disclose scenario. You may be able to pursue a lawsuit for the damages against the seller and real estate agents under various theories of recovery, including but not limited to fraud, deceit, negligent or intentional misrepresentation, and breach of contract, among others depending on the facts of your case. Please be aware there are specific clauses within a real estate purchase agreement in California that may affect your rights and responsibilities to pursue your claim. Now, one example is the requirement for parties to first attempt to mediate dispute before filing a lawsuit. For these reasons, it's crucial for you to consult with an experienced real estate attorney that understands how to navigate and evaluate the facts specific to your transaction and help you determine the best way to pursue your claims and all available damages. Now on to discussing damages. There are three main categories of damages that we at Equity Legal, as experienced real estate attorneys, can help you recover either against the seller or the broker or both. The first type of damages are compensatory damages. These cover out-of-pocket expenses incurred by the buyer to repair an issue or defect that was not otherwise disclosed. They may also cover attorney's fees and any decreases to the property value based on the specific issue or defect not disclosed. The second are punitive damages. These are a little bit more difficult to obtain, but if we can prove concealing the defect was an act of malice by the seller or intentionally done, then you may recover punitive damages. Punitive damages punish the offenders for their malicious actions to deter their behavior in the future. And the final is rescission. In the rare cases where rescission is brought, the buyer may be able to rescind the contract, forcing the seller to take the property back and return the buyer's money and any costs associated with the purchase and put them back as if they never entered the transaction to begin with. Here at Equity Legal, we are uniquely positioned to resolve failure to disclose issues on behalf of buyers because of our extensive experience in defending the brokers and agents and even sellers with failure to disclose issues which have arisen during transactions. This has allowed us to prevail on behalf of buyers and resolve numerous cases, sometimes even prior to filing a lawsuit. Here are some ways we've been able to successfully resolve failure to disclose cases on behalf of our clients. We've recovered the value of repairs incurred by a client faced with structural damage to their property and the costs associated with being required to move out of the property during the repair process due to an undisclosed structural and construction-related issue. In an undisclosed, unpermitted addition situation, we recovered for our clients the value of all costs to repair and permit the property, and attained as damages the difference in the value of the property due to the unpermitted additions. If you find yourself in a situation where you've bought a property and discover an undisclosed issue or defect, it's in your best interest to consult with the experienced attorneys at Equity Legal who can assess the situation and determine whether you have a potential case to bring against the seller and/or the agents and brokers involved in the transaction. If you feel that you've been subject to a failure to disclose issue within your transaction, please take advantage of our firm's consultation by filling out the form on our website with a brief description of your issues, and a member of our team will reach out to schedule a consultation with an attorney to discuss your issues and formulate a game plan to help you resolve those issues.